Hello, I'm Jeremy Cousins. I'm a Chancery Silk from 11 Stone Buildings in Lincoln's Inn. This masterclass is about professional indemnity insurers and their disputes with lenders who from time to time use the services of people such as valuers and solicitors. What I'm going to be talking about is the disputes that arise quite commonly nowadays, and in fact increasingly so, between lenders, mortgage lenders, and professional indemnity insurers. That's to say, the insurers who look after the interests of people such as valuers and solicitors, whom the lenders retain to advise them with regard to such things as the value of property in the case of the valuers, or the solicitors who are responsible for obtaining good title to the security that the lenders want to acquire. Lenders are becoming involved in litigation with insurers increasingly, in my experience, because insurers, in order to protect their interests, are taking an increasing number of points on policy liability in respect of the cover which they give to their insurance clients. The important thing to remember is that when an insurer insures a professional, the insurer can be held liable directly to the lender, as the insurer can be held liable to any other person who brings a claim against the professional concerned, under the provisions of the Third Party Rights Against Insurance, the Third Party Rights Against Insurers Act 1930. The important thing to remember under that Act is that the insurer only has the same liability to the third party that he would have to his own insured. Before a third party can make a claim against the insurer, it's necessary for the third party first to have obtained judgment against the insured and to have that liability quantified. It's not possible for a third party, in instances that we're talking about a lender, simply to begin a claim directly against the insurer. First of all, the third party has to go off, establish the insured person's liability, and then the third party has to bring a claim against the insurer. At that point, the insurer is able to take any point on the insurance policy liability that the insurer would have been able to take against his own insured client. So, for example, a very common point that arises is if the insured has failed to give prompt notification of the claim to the insurer can take that point against the third party if ever the third party should try and enforce directly against the insurer under the 1930 Act. What we're seeing at the moment is an increase in the number of issues that arise under clauses known as single claim clauses, aggregation clauses, and under condonation clauses. Now, these clauses all cover slightly different things, but in the case of single claim clauses and in the case of aggregation clauses, what the insurer is trying to do is to hold the insured's level of cover to a single claim limit. For example, if the insured can make a claim for £2 million on a single claim, the insurer is anxious to try and maintain that where you have a series of claims, those claims are held to a single liability of £2 million, so that the insurer is not exposed, let us say, to half a dozen claims, each of £2 million.